Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am here every Sunday from 8 to 9 a.m. on these stations to bring you, the landowner, valuable information that you need regarding natural gas development here in Pennsylvania. And at the Clark Law Firm, I focus solely on landowner negotiations and representation, not just negotiations, but landowner representation, oil and gas right owner representation, not company representation. Not only do I not focus on company representation, I don't do it. Do not represent oil and gas companies, pipeline companies, never have, never will. So, okay, with that background, what do? Well, I represent landowners for gas leases, pipeline agreements, water line agreements, surface use agreements, royalty and royalty deduction issues, estate planning, amendment and modification of existing oil and gas lease, extensions of oil and gas leases, meter sites, compressor sites, all contracts related to natural gas development. Doing more and more, I have a lot of unitization issues that come up where there's questions regarding whether a property was appropriately unitized. Was the landowner given full credit? We do some deed work at time with these things, corrective deed work. So essentially any landowner representation at all related to oil and gas development here in the state of Pennsylvania. So if you need representation, you can always contact me directly at 570-307-0702. That's 570-307-0702. And to get more information, whether you need representation or not, check out pagasleaseattorney.com. Check out pipelineattorney.com. Great landowner information available there. And also what we do is, after today's show, tomorrow, of course after, today's show will be up and available at pagasleaseattorney.com starting Monday morning, tomorrow morning. And you can go back and look at, we have hours upon hours of shows that are available online for you, the listener, to go check out at your convenience. So, okay, with that said, I'm going to jump into something. I think we have another good show for you here today. Of course, I may be biased since I am the host of the show, but I think we have a nice little show today. I always say I look for things that pop up during the week, and I kind of jot down notes and say, oh, that would be a good topic for the radio show. And by the way, if you're interested or if you have a topic or something you'd like to hear me address, you can go to pagasleaseattorney.com. You can email me there. You can say, hey, can you talk about this? Or I'm interested in this topic. Or a landman came and asked me about this. Can you talk about that? And you know what? If as long as it's a good topic, I'll certainly do that. The goal of the show is to get you, the landowner, valuable information to assist you, to get you thinking. I will say many times the show is not specific advice for any individual, but what it is, it's some general advice. Sometimes it can definitely relate to your particular circumstances, but we want to make sure that you're thinking, that you're understanding, that we want to try to we want to make an even playing field here for you as the landowner, because the companies are educated. Their representatives are educated and experienced, and we want you to be educated, and we want you to have experience assistance on your side as well. So again, I am Attorney Doug Clark of the Clark Law Firm. I'm located at 1563 Main Street in Peckville, and once again, I'm here every Sunday from 8 to 9 a.m. So all right, let's jump to the show here. So one of the things that I'll talk about often is, and this is so very important, it's something came up this week. I talked to a gentleman who is a client of mine, a new client, and was talking to him about, hey, look, you have this pipeline right-of-way agreement offer. You have your oil and gas lease, which I've reviewed and we've reviewed, and you need to know and need to remember that once you sign this pipeline right-of-way agreement, if you elect to do that, well, the pipeline is going to be installed is not going to be installed under the terms of your oil and gas lease, but that pipeline is going to be installed under the terms of the pipeline right-of-way agreement. So if your oil and gas lease ever terminates, well, the pipeline remains in place, if it's still there, under the terms of the pipeline right-of-way agreement. A lot of people, it seems kind of basic, but what we really need to watch out for is the fundamental document that a landowner signs is generally going to be the oil and gas lease. That's the fundamental document. You've heard, I've done shows on kind of being the rule book and the blueprint for activities going forward. Well, many clients, many landowners are then asked to sign or approached to sign other agreements. And as a general rule, almost all of these agreements, if not all, but we'll leave some very few exceptions, they are going to give the company additional powers beyond what's in the oil and gas lease. And also, they're going to give them additional powers, but the activity that the company engages in is not going to be engaged in under the terms of the gas lease, but that activity is going to be supported and authorized by the term of the new agreement. So I gave you the example, a pipeline right-of-way agreement, a roadway agreement. I've talked a lot about roadways. It's a thorn in my side for people out there. I want people to be educated on this, because company comes to you and wants to sign a roadway agreement with you. Well, they want to sign a roadway agreement. There's a really good chance, not always, but really good chance that they need that roadway agreement, or else they can't install the roadway. So you as a landowner could say, hey, I'm not interested in this. Or you as a landowner could say, hey, you know what? I'm not interested in this roadway, certainly at the compensation that you're offering me. Also, I don't like the terms, meaning the language in the agreement that you're offering me. Sometimes these agreements don't even have indemnification language. So God forbid somebody gets hurt out there, may you be responsible. And maybe if you're not responsible as you didn't do anything, well, you can run into a problem of responsibility just in being sued. So if you're sued, then that alone can be a major problem for you, because you're going to have to defend that lawsuit. So that's obviously a very big issue. So we want to make sure not only are you protected as the landowner and you're protected from liability in case somebody or something gets hurt or damaged, but we also want to make sure that you're not going to have out-of-pocket expenses in this process. We don't want to see you get sued, have to retain a lawyer, spend $5,000 or $10,000, who knows, maybe more, just to get the case dismissed. Well, who wants to do that? Then you think about, okay, well, I had this roadway agreement. They gave me, say, $5,000. Well, now I spent more money than that in trying to get a case dismissed that was filed against me because that somebody was hurt out there, and I was just a named defendant. I was never even there. You might have been in, Wyoming, and you just have this property out there. So it doesn't stop you from being sued. Talk to clients about that all the time. We want to do two things. We want to protect you from liability, but we also want to make sure that if you're sued, and even if you did nothing wrong, you can still be sued. Then you have to defend the case, and obviously the longer it goes, the more costly it's going to be, the more wear and tear it is on you emotionally. It's not fun to be sued. So we want to make sure that we're going to protect you in every way possible. And there's so many of these pipeline, roadway, surface use agreements, and other documents that aren't protecting you on one of the most fundamental, important provisions being indemnification. They call it indemnification, liability, hold harmless provisions. You need to make sure you have those. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 on these stations. And we'll have this show archived and placed up on the PA Gas Lease Attorney.com tomorrow, Monday morning, as well as we have many hours of other shows available at PA Gas Lease Attorney.com. So, okay, to finish along these lines, it's not just, we talk about pipelines, roadways, surface use agreements. You have to make sure that you're getting this protection and this coverage. And I'm just giving you one small example. Now, I talked about, I'm going to stick with this, and this is an interesting case. Had a gentleman who came in, he called, and he had a roadway agreement. And that roadway agreement was $750 he was offered. And I've talked about this with clean and green issues, which if you missed that show, you should go back to VA Gas Lease Attorney and check it out, because landowners are not aware. Companies aren't telling them. I don't know if landmen are not aware or they're just not telling people, but roadways, surface sites can and should, in most cases, affect your clean and green status for that property, which means heightened or increased taxes on an annual or yearly basis. So in this case, this is a great example. Landowner offered $750 for a roadway agreement. Well, thankfully, he called me. Not that I'm some kind of genius, but I understand what we're doing here. So he calls me and I say, well, look, few things. I've reviewed your lease. I've reviewed this map. I've reviewed what's going on here with this roadway. And in my opinion, the company does not have the authority to do what they want to do with this roadway under the terms of your gas lease. So you can either say no or negotiate. Now, they do have some authority, and there's a complicated little technical issues here, but they had some authority for a roadway, but not the authority to do the roadway that they wanted to do. So what do? Well, we say no, and we negotiate. We go back and forth. Jumping to the end of this, well, now it went from $750 with a absolutely terrible language agreement, where the landowner would have to pay increased taxes annually. So within a year or two in this case, he would already be losing money and continue to lose money every single year and have this unsightly roadway traveling through a large portion of his property that he didn't want. So fast forward, well, now we're looking at $25,000 or so to be the compensation. We have limitations. The agreement has changed drastically, and the individual ultimately says, hey, you know what? Based upon all these changes, based upon this increased money, I'm comfortable. I'm going to go ahead and do this. So had this landowner, many landowners are doing it out there. Landman comes out, oh, we want to put this roadway there. What are they going to preach? Royalties. You're going to be rich. Here's my pen. That's what they're going to say to you. That's what they always say. If you're listening, you've dealt with these guys, you know that's what they always say. So in this case, if you buy what they're selling, well, what are you going to have? Well, you just bought yourself a $750 easement agreement for a roadway that can be there. And the way this was written was as long as they were operating in this region or area, which is, who knows, 100 plus years. So you got yourself a roadway that could be for 100 plus years. You received $750 in compensation. Now you have to pay taxes on that. And now, because of this roadway, it's going to take you out of the Clean and Green program. And now you're going to have a higher tax rate on the portion of your property where this roadway is located. So now you've just agreed to lose money for the next 100 plus years. And also, if that wasn't enough, you exposed yourself to liability because there was no indemnification language in the agreement. It's insane. It really is insane. And there are people out there signing those. So please, ladies and gentlemen, please be aware of these situations. Be aware of these circumstances. As I'll say many times, call me or call somebody else, but call somebody and get informed and understand what's going on here, because this gentleman now has made more than 25, 30 times what was offered. He has a much better agreement for him, and he's much happier. And had he just signed, he would have been in a completely and totally different situation. Okay, I'm going to talk more about these future documents because it's something where many areas of the state we have people who have already entered into leases and we're transitioning. Some areas are being heavily developed and are literally pumping gas and royalties, but others are starting into that phase. So no matter where you are, it is very common for landowners to be offered subsequent agreements after they've signed their oil and gas lease. And one of the things I want to talk about is a ratification, amendments. We want to talk about making sure that you are not changing your original agreement, which you've negotiated for, unless you are comfortable and you're okay with what they're asking. And the original agreement, I'm talking about the gas lease. But no matter what, future agreements may alter, impact, or cancel prior agreements, and you must you must understand what you're signing and what the impact of the new document is going to be on any other documents you've signed in the past. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 on these stations. And you can check out pagasleaseattorney.com, where we'll archive this show and have many, many others available for you at your leisure. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, I represent landowners and only landowners. If you want to give me a call, you can always contact me directly at 570-307-0702. You know, I have clients all across the state of Pennsylvania, and I have clients across the country at various times to represent people who have oil and gas rights and interest here in Pennsylvania. So one thing that we've learned with modern technology, distance from my office, and I'm at 1563 Main Street here in Peckville, Pennsylvania, has not really ever been a problem. And you've heard me say clients I've represented in London, Alaska, Hawaii, Micronesia, which is my favorite one to say because pretty far away. So we haven't really had any issues there. So if you're looking for representation, you can always contact me, 570-307-0702. And I mean this. If you don't contact me, please contact somebody, because we're seeing people every day sign really bad agreements. I think I gave you a pretty good example there. It was somebody's document who went from $750 and a lifetime of losing money on a roadway to $25,000 and being covered for future expenses and liability issues. Okay, I want to continue on here. So what I was talking about, I want to continue to talk a little more about, is your basic fundamental document is going to be the oil and gas lease in most cases. Some people do not have an oil and gas lease, and they're asked for something like a pipeline right-of-way agreement, maybe a roadway agreement. That's not common, but certainly it occurs. And in those cases, you really have a lot of power and ability to negotiate or simply say no. You have it's an entirely different circumstance. But what I want to focus on is, in most cases, the landowner executes the oil and gas lease. That's going to serve as kind of this foundation for future activities on the property, and what the company can do. So the stronger the gas lease, the more limitations that you're putting on the authority of the company and how they're going to operate in the future. So we want to have the strongest possible oil and gas lease to give you, the landowner, as many options in the future, and to control and the authority that the company has. Where is the roadway going to be? Where are pipelines? What type of pipelines? Where can the well pad be? How are they going to reclaim? What's going to be the size? How much money am I going to get? All of those things are things that we're going to be looking at, and you need to be looking at when you're working on the oil and gas lease. So now we're talking about, after you sign your oil and gas lease, company comes to you and wants you to sign future documents. Very common examples: pipeline right-of-way agreement, probably the most common. We also have roadways, surface use agreements, meter site, compressor site, storage site, pipe yard, staging area, many other agreements that are possible, water line agreements, water impoundment ponds, all kinds of other agreements you may be asked to sign in the future. You need to be careful. Those documents are generally going to give the company the authority to operate under the terms of those new documents, or that new document, not the oil and gas lease. So normally the company's going to be asking you to provide them rights that they do not have, or go beyond what rights they have in their oil and gas lease. That's the normal case. So there, if you're going to be giving them something, you should be receiving something in return. And this isn't something novel. This is what occurs. You negotiate and you say, hey, wait a second. If I'm going to give you this, you don't have the right to do this. The quid pro quo, what am I getting back? So you negotiate that. And if you can't reach an agreement, you have the ability to say no. You simply say no and thank you, and you part ways. But a lot of times what we do is we're able to reach agreements, and typically they are for, often more compensation, and also, in almost all cases, much better language that's going to be a lot better for you, the landowner. One of the things to talk to people about, I hear this all the time, it's not about money, it's not about money, and I certainly respect that, and sometimes it's not about money, but what I'm saying is, I guess my point, I have this conversation with the gentleman. Okay, I understand it's not about money. We're engaged in a negotiation for one of these interstate pipelines with condemnation, eminent domain issues. But I say, well, look, if you're going to ultimately sign the same exact agreement, same language in this agreement, well, wouldn't you rather have $40,000 instead of $30,000? So, yeah, maybe it's not about money. That's not what the driving point is. But hey, we want to maximize the money. I mean, you just want to do that. Common sense. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 on these stations. What I'm talking about now is subsequent agreements after the oil and gas lease. Now, those same things come in with other documents as well. And what really got me going on this path, and I've talked about this before, but what's got me on this path this week was I had a client about 6 months ago who signed a pipeline right-of-way option agreement. Pipeline right-of-way option agreement. Now, this option agreement said essentially that the company was going to pay a certain amount of money up front where they're buying an option, where they're saying, for example, I'm going to give you $10,000 today. That $10,000 in this case gave the company a 6-month window to decide whether they were going to what's called exercise the option. Are they going to actually use the agreement? Now, of course, think about it. We want to get the most money up front in case they don't use the agreement. At least you get that money. Company wants to pay the least amount of money up front. So if they don't lose or use the agreement, they don't lose that money. So in this case, we've got a pretty good option payment in this circumstance. So you got $10,000 up front and said you got 6 months to decide to exercise this option. Now, the exercising of the option is another, I'll call, event in this process. Well, how do you do that? Do you call the landowner up and say, hey, Mr. Jones, I'm going to exercise the option here? Is that good enough? Do you send a letter? Do you send money? So in this case, what we did was, and this is pretty ideal, we want to say, okay, you have 6 months. Within those 6 months, you need to decide, company, are you or are you not going to use this option? And if you are going to use it, if you are going to exercise the option, here's what you must do. You must send a letter to the landowner, certified mail overnight, but you must send a letter, and simultaneously with that letter, you must tender or send a payment. And I'm going to make this number up, and it was actually higher, but I'm going to make this number up. Let's say that payment was $100,000. So what we say is you give the landowner $10,000 today. Now you have 6 months to decide, are you going to use this pipeline right-of-way option agreement? Within those 6 months, if you are going to use it, calling us up and telling us that's not enough, writing a letter, that's not enough. In order to exercise this option, you must send written notice, correspondence, letter to the landowner, including a certified check in the amount of $100,000. Well, why do we do that? Well, there's some obvious reasons, but then also what we want to do is we don't want to just, hey, send a letter. Sometimes these option agreements will be written where they have to notify you. We'll stick with this example. Say it said we have to notify you in 6 months, but then we have so much time, maybe it's years, to actually construct a pipeline, and we do not need to pay you the money until we commence operations, meaning start working. Sometimes it'll say within 60 days after they start working. So here you are, a landowner, you're thinking, all right, great, within 6 months I'm going to get $100,000 if they're going to use this. However, here comes 6 months and you get a letter, landowner, please accept this as notice that we're exercising the option. We will make the payment within 60 days of commencement of operations. Well, you better have some language in there When do they have to start? Can they wait 5 years, 2 years, 1 year? When do they start? So ideally, in my opinion, we want to have that you signed for, in my example, $10,000, which is a nice option chunk in this case. And then if they're going to exercise within 6 months, they have to send you a check for $100,000 with notice that they're going to exercise the option. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 on these stations, and I represent landowners and only landowners. So, okay, talking back to this option. So what happens here? Another important provision, and it's often overlooked in leases, pipeline right-of-way agreements, and pretty much all documents that companies ask you to sign as a landowner, there'll be a provision in there, and it's written different ways. But essentially what it's saying is that you as the landowner agree to sign future documents as necessary to carry out the purposes of this agreement. And sometimes it'll say that you'll agree to sign affidavits, and driveway permits will be a lot of times things like that. But the idea is they don't want to have a situation, the company doesn't, and this is a fairly reasonable request in most cases, they don't want to have a situation where they enter into an agreement with you and now they need your signature on some form like a driveway permit with PennDOT and you refuse to sign, and it creates a lot of problems for the company. Or in this example, what happened was we signed the client signed the pipeline right-of-way option agreement. The company had 6 months to exercise the option. Well, here we are closing in very close to this 6-month period, and then we get a set of documents that the company says, oh, we'd like you to sign. Now, one of the documents, you want to always look at these very carefully. One of the documents was what we call an affidavit saying, okay, I swear that the following information is true. Landowners, please understand that you're swearing that the following information is true. Watch these documents. You need to make sure that you can say this is true. If you don't know it to be true, you shouldn't say it is true. Because if something happens later and it wasn't true and now there's a problem, the first thing that gas or pipeline company is going to do is hold up your affidavit where you swore that the information that you agreed to or you stated in this document is true. And remember, you're not the one writing this document. The company is presenting you with an affidavit listing all of these different statements that they want you to sign off on as swearing to be true. So please be careful and make sure that everything in this document that you're going to sign, if you're going to sign an affidavit, is true and correct. If it's not, don't sign it. Tell the company the problem. Quick example. Sometimes I'll see landowners asked to sign a document that says, I've been in possession of this property for the last 20 years, when in fact they only bought the property 5 years ago. Well, how can you do that? You can't do that. You can't truthfully do it. That's just one real simple example. So please be careful on affidavits. All right, let me reset now. So, okay. Landowner signs the pipeline right-of-way option agreement. Now it's closing in on 6 months. It was a 6-month option. We get these documents, one being an affidavit. And what they're really looking at here is to make sure that the landowner in this 6-month period, that the landowner didn't take out a new mortgage, enter into any other agreements with any other companies, or do anything, or sell the property and not tell them. The company wants to make sure that the landowner didn't do anything in this 6-month period with this option that was existing, that they didn't do anything that would impact the company's ability to move forward with the agreement. So, pretty reasonable. We want to look at this and we determine, okay, hey, yeah, this is reasonable. So we go through, we make sure there's nothing there's any issues with, and say, okay, this is a reasonable request under the existing right-of-way agreement. We agree as the landowner signor that you are willing to and will sign any documents reasonably requested in the future, including affidavits that the company may require. Fits right in there, no problem. However, when we get back, I'm going to talk to you about another document that they sent. And unfortunately, well, however we want to look at this, we can't sign this document because there's no obligation to do it. And what's it going to do? It's going to change, and significantly change the underlying pipeline right-of-way option agreement that requires payment of $100,000 within 6 months from signing if the company is going to exercise the option. I'm going to talk about what else they try to sneak in here, and thankfully, landowner gets the document sent in to me, and we say, ho, wait a second, not going to sign this, here's why. I'll be right back to explain all of this. You're listening to Attorney Doug Clark from the Clark Law Firm. I'm here every Sunday from 8 to 9 a.m. on these stations. I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Always remember, you can contact the office anytime, 570-307-0702, anywhere in the state, anywhere in the country, 570-307-0702. I represent landowners and only landowners. So if you're an oil and gas company, please don't call for representation. Not that I think you will. Okay. So what I'm talking about, and this is a great example. The whole show so far has really been about future documents where you're signing an agreement, whether it be a lease, a pipeline right away, any agreement that you sign, and then the company comes back and wants you to sign additional documentation. Sometimes the additional documentation is related to a prior agreement, like a gas lease. What I'm going to talk more about here now is a pipeline right-of-way agreement. But sometimes they're totally unrelated. Like you enter into a gas lease, and now a separate pipeline company comes in, wants to install a pipeline right-of-way, totally unrelated to the gas lease, or it could be related, but it's still a separate agreement. So what we're talking about here is, you got to look at these. You got to understand your leverage. And you got to understand, is what you're signing, is that changing the terms of your initial agreement? And generally, it's going to. I gave the example, a pipeline right-of-way agreement. When you sign the pipeline right-of-way agreement, that pipeline, if it's going to be installed, or pipelines under that agreement, will be installed under the pipeline agreement, not the gas lease. Same thing with even a surface use agreement for a well pad. If you're signing an agreement for a well pad, well, that well pad is going to be placed under the authority of that new agreement. Got to be careful about these things. Got to be careful. Remember, nothing is ever specific advice. These are things we need to be thinking about. You have to, anytime, please, before you go sign any document whatsoever, call me, 570-307-0702, or call somebody else who's experienced, who understands, to make sure that you're not making a mistake, because people, unfortunately, are making these mistakes all over the state. And it's a shame to see, and we want to try to stop it. So, okay, I was given this example, and this is something we fought long and hard. Remember, you negotiate, you fight. You're working for these terms in these original documents, not for the company to just throw away a year later, 2 years later, 5 years later, 6 months later. No, you've negotiated these terms with the idea that the company is going to follow them. As the company expects you to follow your agreement, you expect the company to follow their agreement. Pretty basic stuff here. But what happens is, often the company will come, give you a different agreement or a different document, which may change and sometimes significantly change or alter the prior agreement you signed. So again, here's the situation. Client, we'll say on January 1st, enters into actually it's a little later. So we'll say in January, we'll do it this way. January 1st, landowner enters into an agreement that says gas company has to give you $10,000 for a 6-month option. Pipeline company. So the pipeline company gives the landowner $10,000 up front. Now has until June to decide whether they're going to exercise this option. And then if they're going to exercise the option, how do they do that? Well, in this case, we were able to negotiate very favorable terms for the landowner. And really, this should be common terms with pipeline option agreements or any option agreement, saying that within 6 months, the pipeline company has to pay $100,000. They have to send a letter, correspondence to the landowner saying, we are actually going to now exercise the option, meaning we're going to use this agreement, and here in this letter is a check in the amount of $100,000. So everything is very clear and neat. Landowner goes, deposits the check, understands, okay, agreement has been exercised. That no longer is an option agreement, it's now a pipeline right-of-way agreement, essentially. So in this scenario, as we approach the 6-month deadline, the company asked the client to sign an affidavit to make sure that nothing occurred within this last 6 months that they're unaware of that would somehow impact negatively their rights under the pipeline right-of-way option agreement that the landowner signed 6 months ago. Reasonable request. We review the affidavit to make sure everything is true and correct and say, okay, no problem signing this. Plus, as almost all agreements do, they have language in there saying that you will sign any reasonable documents necessary to carry out the purpose of these agreements. However, landowners, you don't have to sign anything or everything that they put in front of you. You only have to sign what is necessary, reasonably necessary in the future to carry out the purposes. Doesn't mean that you have to sign anything that is going to change that original agreement. Okay, very, very important. And here's what happened. So, company sends to my client, who sends to me, an affidavit saying, okay, and there's a lot of different things in there, but essentially saying that nothing's occurred in this last 6 months that would create a problem for the company to move forward under the agreement. Reasonable. No objections there. Makes sense. We'll go ahead and make sure it's true, and go ahead, client, you can sign it. However, the next thing with this document was another document, and this document was called Acknowledgement of Notice of Exercise and Authorization to Record this easement agreement once the option was exercised. Couple things there. Number one, in this case, the agreement itself, the actual pipeline right-of-way option agreement, says expressly or specifically that once the company sends the $100,000 check and sends the letter saying we are exercising this option, the company then shall record the pipeline right-of-way agreement at the county courthouse. Shall record. That is required. So the landowner is not required to sign another document to say you now have authority, company, to go ahead and file this document at the courthouse. There's no requirement to do that. However, look, is this something we want to make a big issue out of, we want to fight about, or just say, hey, listen, it's in the agreement, there's no need to sign? So that's probably the best approach initially. However, believe me, I wouldn't be talking about this if this was the only thing that they asked. It went on to say that the undersigned acknowledges that the final payment owed between this landowner for the conveyances set forth between the parties shall be, and then there's a blank. Well, my office, we have a policy. We don't sign agreements with blank spaces. We like to see what's going to be in those blank spaces before you sign. So, may sound silly, landowners, please don't sign agreements where there's blank spaces. But it gets worse. It gets worse. So the next sentence, which they send to the landowner requesting they sign, and I've said how many times, the agreement says, within 6 months, you must, company, send the landowner a letter and $100,000 within 6 months, or this agreement's off. So here's the next sentence. It says, the undersigned, or landowner, hereby consents to receive such final payment by hand delivery. Okay, well, we said you got to mail it, but if you're handing it to me, maybe I'll sign a receipt. But, well, pay attention here, please. So it says, the landowner hereby consents to receive such final payment by hand delivery at a date and time following, and it says there's a blank there, Believe it or not, it's a blank. So it's saying now that you're agreeing as a landowner to accept final payment at a date and time following some unknown time here. And then it says, which time and date shall be mutually agreed upon by the undersigned and the company. So let me do that again, because it's pretty remarkable here. So our agreement says you got to send a letter and $100,000 within 6 months. What does the landowner get? They get a document that has this language in it saying that you, the landowner, consents to receive final payment by hand delivery following a certain date, which date and time shall be mutually agreed upon by the landowner and the company. You're agreeing to accept payment at a future time that you and the company agree on. It's unbelievable. It is unbelievable. The agreement says you must pay $100,000 in 6 months to have an agreement. They send a document saying, hey, landowner, sign this. And the document we want you to sign says that you're agreeing to accept payment at a future date that we shall mutually agree upon. Well, that's never going to work. That's not going to work. And let me ask this question. Okay, we have an agreement that says you have to pay within 6 months, so it's over. This agreement's over. And they need this agreement, and we know they need it. So now they're going to say, not only are we asking you, or we're asking you to sign something that we don't have to pay in 6 months, which isn't the deal, but also saying that not only are we not going to pay in 6 months, we're going to pay you at a time in the future that we shall mutually agree upon. Well, when in the world is that going to be? How do you say something like that? When is that going to be? What if I say, all right, here goes the 6 months. Now we're in 7 months. Now we're in 8 months. Hey, company, I'd like to get my $100,000. How about we get this payment? Pick a date, September 1st. Company says, we don't agree to that date. Well, what do you mean? We don't agree to that date. Well, the agreement says here, what they want you to sign, says that you're going to be paid at a date and time which shall be mutually agreed upon. So if one of you don't agree, you don't have a mutual agreement. So who even really knows what this means? It's really saying, really, when you dig down, it's saying, hey, yeah, we'll pay you when we feel like it. Well, we went through this process and negotiated an agreement that required $10,000 up front and $100,000 to be provided at the time the company notifies the landowner that they're going to exercise this option. Not that you're going to throw some document out to the landowner right towards the end of this 6-month period, which is going to change everything. Some of the most critical terms here that's going to change it, that not only do you not have to pay in 6 months, you don't have to pay until you agree on the landowner or agree with the landowner to pay. So if you don't want to pay now, you just don't agree to pay now. However, your written contract says payment must be made in 6 months. So of course, we're reading the documents, we're understanding this, and which is unbelievably remarkable that a company would send something like this to a landowner. And I'm sure they sent it to many other landowners who are part of this pipeline right-of-way easement corridor. So they send it to everybody, and probably vast majority of the people signed these things. So if you had some sort of requirement of payment in your agreement, well, you just signed something that's changed your payment terms, and you didn't even understand it. So you look at it and you say, well, no, I'm not going to sign this. This isn't reasonably necessary to carry out the purposes of our original agreement. Quite to the contrary, what it is it's a significant material change to our original agreement, and I don't need to sign it. You as a landowner do not need to sign anything that's going to materially or significantly change the original agreement under an idea that you have to sign future documents to carry out the purpose of your agreement. Don't need to do it and shouldn't do it. So what do? Hey, company, we got this affidavit, we understand it, and that's a reasonable request. We'll go ahead, we'll sign it and get it back. But hey, unfortunately, The other document you asked the landowner to sign, we won't be signing that and sending it back in. And if you do not pay within 6 months, this agreement will be null and void. So you can decide how you want to do this, but you need to pay this money if you want to continue this agreement. So, long story short, I guess a very long story with an ending. And the ending is, okay, we'll send a payment. So they really don't have a choice because that's what the agreement is. So when you get these future documents, you need to be careful. You're not changing the original agreement. And sometimes it can be very, very significant. Look, the companies do it all the time. Hopefully you see how egregious this can be. This example. But there are so many others. I'm up against this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always contact me at 570-307-0702. That's 570-307-0702. I solely represent landowners and oil and gas right owners, and I'm here if you need me, and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm located in 1563 in Peckville, Pennsylvania. You can always contact me, 570-307-0702. That's 570-307-0702. Make sure you go to pagasleaseattorney.com, pagasleaseattorney.com. Great information for you as for the landowner. We also have today's show. If you miss any of today's show, want to go back, listen to any of the prior shows. And I wouldn't go through a show without saying that I started doing this show in August of 2010. August of 2010. So I'm pretty proud of that. So you can go back. We don't have all those older shows archived since we've renovated the new website, but we do have many hours worth of shows for you to go check out, get some good information, learn some more, good information out there. Also, you can check us out on Facebook. You can get to that through the website. You can also follow me on Twitter at Doug Clark Law. Check out all the different things we have to offer, whether you're looking for representation or not, and also, of course, pipelineattorney.com. I talk a lot about pipelines. I think I have been giving them a break quite a bit, but I do a lot of pipeline work. I've said this before. I think I can comfortably say that I've worked on files and pipelines with over 50 different companies in Pennsylvania. 50 different companies. So, when you talk to somebody and they have some experience where, maybe they dealt with the pipeline company for their pipeline, I assure you, the more companies that you deal with, the more experiences you have in negotiations, the better equipped you are to do better in every single case as you move forward. So very, very important. I have many times where landowners say, well, my neighbor, he did an agreement, so-and-so did an agreement, and they're helping me. Please be careful. Please be careful, because there's a lot of tricks, techniques, things that you can do, evaluation of leverage, and a proper evaluation of leverage. And I'm not kidding on this. A strong evaluation of leverage can really change offers by the hundreds of thousands of dollars for pipelines in certain cases. Okay, so it's important that we look at every individual case. You look at your individual case as an individual and not as what your neighbor did or somebody else, even if it's along the same lines. You don't know what your lease you don't know what their lease says. You know what your lease says. You don't know if there was an option to easily bypass the neighbor's property, but not with you. There are so many things that we need to look at, and strong evaluation and an assessment is going to give you not only the most money, but the best terminology, the best language, the most property protections, the biggest restrictions in your current agreement. So we have to be looking at these cases individually on an individual basis. There is no set plan for anybody. Every single case is a different case. Some cases are very similar to others, and we understand that. We evaluate it, and we understand that leverage, but You need to come into every evaluation as if it is a blank slate, because it is. Every time you're dealing with a new client, or every time dealing with a new parcel, and every landowner, you're unique. And we need to make sure that we're looking at all your different options, and that you're educated and informed, and you're using your leverage to the best that you can in the way that you want to. Again, I'm Attorney Doug Clark. You're listening to All Things Marcellus here in these same stations every Sunday from 8 to 9 a.m. So, okay, I was talking about, and I'm going to just finish up on this too, was talking about these future agreements. It is so important. You want to negotiate. You want to get the best possible oil and gas lease. When you sign your oil and gas lease, you want to know where it's strong. You want to know where it's weak. You want to understand, when I sign this, where are there limitations where a company can operate on my property? Maybe you can eliminate all operations on the surface of your property. Maybe you can't. If you cannot, well, can you have input? Can you have some sort of dialogue with the company and consent, perhaps, where you would agree where the company can or cannot operate? Then often you're going to have some sort of caveat in there saying, company will say, yeah, we'll work with you on location, but you can't be unreasonable. Well, you need to understand, well, what does that mean, and how may that impact me in the future if I don't like where the company wants to operate, or even if I get that knock on the door saying, hey, we want to operate on your property. Well, pull out that lease and see what kind of rights you have. And if you don't have any rights in there and you don't like what they want to do, you're going to wish you knew that, you're going to wish you negotiated it, and you're going to wish you had rights and input. So very, very important. I deal with that issue very often, very, very often. So we want to make sure that you have the strongest possible oil and gas lease. Another very big thing, I talk about doing pipeline and working with about 50 different companies and pipeline negotiations and pipeline matters. We want to make sure that we limit the company's ability to install pipelines in the future. A good solid agreement for a landowner, a lease agreement, can totally eliminate future pipelines, even future roadways, well sites. But for now, we'll say pipelines. We want to eliminate them or restrict how many lines. Lines that only carry your gas. Lines maybe that carry your gas mixed with others. A lot of different language there. That language has really important meaning. So as a first-time reviewer of this language, or maybe reviewed it a few times, okay, how does this work in the future? One of the things that I'll say to my Tioga, Potter, some of the Western Pennsylvania county clients is, hey, look, when you're doing your gas lease now, I'm going to tell you what we see in some of these much further developed areas, like Susquehanna County, like Bradford County. I can tell you, here's what we're seeing, 7 years, 8 years, 10 years out from landowners signing leases. So what may be important for you? What are we seeing moving forward? So we have this, I always talk about this evolution or this wave of development across the state. So what we want to look at is, okay, we have a basis that we can gather from and learn from other areas that are further along in development. So take a Potter County, take a Tioga County, in many areas where you're not seeing all of these pipeline agreements, and you're starting to see more, but go to Susquehanna County where pipelines are everywhere and more agreements are coming all the time, and doing pipeline agreements there probably over 5 years. So now you're talking about some areas where we're just starting to see pipeline right-of-way agreements appear. What do we want to do? We want to be aware, what problems are we observing in Susquehanna County, where there's a lot more pipeline right-of-ways, where these agreements are in place, and where landowners are calling, complaining, and saying, hey, they're doing this, they're doing that. But then we go back and we see that the agreement, they didn't have an attorney, or they didn't know what they were doing. They entered into this agreement, and now we're seeing how the company is taking advantage of that. So talk to the Potter County landowner, Tioga County landowner, say, hey guys, let me just tell you, here's a term that the company has in here that I think you want to change, because here's what we're seeing as the result of that term. Here's what we're seeing, how that's being used to the detriment of landowners. So we want to make sure that we eliminate that, or you're aware of that. Just one example. Well, I'm up against it again, but listen, I want everyone to have a wonderful week. It's been good being with you. I'm here every Sunday from 8 to 9 a.m., and I'll be back next week. So have a great week, everyone.